Drug distribution and possession with intent to distribute in Louisiana. Drug distribution refers to the sale, delivery, or transfer of a controlled substance, while possession with intent to distribute involves possessing drugs with the intent to sell or distribute them. A distribution case is straightforward. The defendant is accused of selling drugs to another person. Despite this assertion, there are a variety of legal issues implicated within these prosecutions. The first issue is identifying to whom the person sold drugs. It is going to be one of three people: an undercover officer, a confidential informant, or a co-defendant. The most common prosecution involves the sale of drugs to an undercover officer on multiple occasions. Normally, an undercover cop is introduced to the drug dealer through a confidential informant who arranges for a drug sale with the accused, in which the undercover police officer participates in the sale. This makes the officer a material witness to the criminal activity and allows him to testify about the distribution with first-hand knowledge. Many of these cases involve audio and video recordings of the drug transactions and setting them up. These cases are harder to defend because the identity of the drug dealer is captured on the recording, and the audio of the transaction makes it less likely the accused can argue an entrapment defense. The second type of drug distribution involves co-defendant testimony. This can come in one of two forms. The most common is a co-conspirator who is cooperating in exchange for leniency. This allows for the prosecution to introduce co-conspirator statements between the conspirators as an exception to the hearsay rule, allowing the prosecution to establish the defendant's knowledge of the crime. These prosecutions are more extensive as they allow for the co-conspirator to discuss the manner and means of acquiring wholesale drugs, their distribution channels, and where the drugs are concealed and processed for sale. The other, and less common, co-defendant prosecution involves using the purchaser of the narcotics as a witness. In these cases, typically the police conducting surveillance observe a drug transaction and radio patrol officers to take down the buyer's car. During the course of the traffic stop, the patrol officers will attempt to manufacture probable cause to search the vehicle and find drugs. Often, in exchange for testimony regarding the source of supply, the buyer's possession charges will be dismissed. The least common drug distribution prosecution involves using a confidential informant. These cases are rare because the state has a vested interest in protecting the identity of the informant for safety concerns. However, if they chose to proceed with prosecuting informant-only drug sales, they will need to burn the CI and reveal his identity. Also, they will have to inform the defense about any evidence they have that impeaches the credibility of the informant. For example, is the informant being paid for his cooperation? Is the informant working off charges? Meaning, will the police forego arresting the informant on some other charge in exchange for him assisting in facilitating drug deals on behalf of law enforcement? And, what is the criminal record of the informant? These prosecutions are ripe with evidentiary issues that make prosecution more difficult. First, these cases are susceptible to entrapment arguments, especially when the conversations setting up the drug transactions are not recorded. Second, an informant is inherently unreliable. They have a vested interest in having other people arrested and convicted. Third, their availability for trial is uncertain. Many informants are drug addicts, and keeping them sober throughout the court process can be difficult. Possession with intent to distribute cases. These cases are quite common and, in many respects, are simply enhanced versions of drug possession prosecutions. So what makes a possession with intent to distribute case as opposed to a simple possession drug case? There are a variety of factors to consider. First, there is the quantity and type of drugs. There is only so much drugs a person can possess before an argument of having it for personal use becomes untenable. There is a huge difference between 5 grams of cocaine and a kilo of cocaine. One is indicative of personal use and the other is obvious drug trafficking. Also, the presence of multiple narcotics indicates drug trafficking. Someone may have a vice with 1 or 2 substances, but when they are found to possess many substances, even in smaller amounts, it suggests they are a low-level dealer. The second factor to consider is the presence of tools of the trade. Drug users will possess the drugs and the paraphernalia to consume them, whereas drug dealers will possess the means to produce and package them. Drug dealers will commonly possess digital scales, vacuum sealing equipment, and a large selection of Ziploc baggies in a variety of sizes. The more sophisticated dealers will also be found to possess drug ledgers and equipment to produce drugs for sale. This can be pill press machines, cutting supplies that reduce the purity of drugs and expand the quantity for sale, or items used to prepare narcotics with residue located on them. The third factor is cash. Drug dealers tend to have a lot of money on hand. Whenever someone secretes large amounts of cash throughout their residence or inside of their car or on their person, it is a factor to consider as to whether the person is a drug dealer. People carrying $100 or so is not uncommon, but carrying thousands of dollars will be. Similarly, It is unusual to conceal $100,000 or more inside of a home. The fourth factor is law enforcement knowledge. Often, possession with intent to distribute drug cases arise out of the execution of a search warrant where a stash of drugs and manufacturing materials is located throughout the house. The basis for obtaining the search warrant is normally inadmissible at trial unless the prosecution wants to reveal informant identities, but what the officers do prior to executing the search warrant is fair game. In many cases they will conduct pre-execution surveillance and report observing drug trafficking activities. For example, they may report seeing the accused engage in multiple hand-to-hand transactions or report seeing many vehicles approach the residence and people go inside for only a few minutes before leaving, which is something unusual in normal situations. The presence or absence of any of these factors will go a long way in determining the appropriate charge for someone arrested with drugs. The penalties for possession are far more lenient than those for distribution in Louisiana.